Right. Before we get started, I'll just do a brief introduction for the people who will be watching this. Professor Samuel Moyn is the Henry R. Luce Professor of Jurisprudence at Yale Law School, United States. He has done groundbreaking work on human rights and now has taken up the very admirable cause of progressive constitutional reform in the US. Professor Moyn, it's really great to have you with us. I will not beat about the bush. I will get straight to the point. In a rather fascinating article you wrote for Dissent magazine, The Court is Not Your Friend, you made the argument that general fear of majoritarian tyranny in the absence of a constitutional court with the power of judicial review was unjustified, or in your opinion, it was unjustified. And I think that's a great point for us to start on. What is your rationale behind that argument? Why do you feel that we in liberal democracies have this notion that we need a constitutional court to protect our rights from the tyranny of the majority of the day, that legislatures cannot be counted on to protect individual rights? So what's your rationale behind saying, no, that's not the right approach?
So I begin with kind of an empirical or factual claim, which is that so far majorities have never exerted much power in history, and from the beginning, in principle and in practice, it's really minorities that have ruled. If there's been tyranny, it's been the tyranny of one or a few, and certainly of minorities. So before we place constraints on majority rule, I think we should first have it. And, to the best of my knowledge, really nowhere in the world has majority rule ever been established in fact. And if that's the case, then we can't really, assess reasonably what the risks that it poses are, including to minorities. I fear that most of the dominant argument about the purposes of constitutionalism, which have come to concern protection of minorities against majorities, are really the arguments of those who resisted the coming of democracy in the first place, who said that democracy would be little different from mob rule. That was, of course, Plato's argument at the beginning of philosophy. And it was, of great currency when the franchise was expanded in the North Atlantic and in Latin America in the later part of the 19th and early 20th centuries. Now, in fact, if we look, we do find some instances where minorities are oppressed. It's an open question if we haven't yet enfranchised all minorities or given them a place in national politics, whether it's the fault of majoritarianism or some other minority. Since, as I've said, we have had lots of experience with minority rule, including once democracy came, through various devices. In my country, which I focus on in the article you mentioned, the Constitution was really set up on the basis of popular self-government, to channel power away from the people in a series of ways, and especially from majorities. And the Supreme Court is one way in which this occurs. I don't contend in the end that majority tyranny can't be a risk. And I'd acknowledge that at certain places and times it's been incurred. The question is how to counteract that risk. And, what the relation of that risk is to the minority tyranny I've been, stressing. So I guess looking out at the world, I don't see a strong basis for judicial empowerment in particular. Even acknowledging we need some remedy for minority protection, the onus seems to me on those who defend transfer of lots of power to judiciaries to protect minorities. Because that's where the argument has to rest. And it's there on that narrow argument that I don't see a strong case. And I see many reasons to worry that transfer of power to judiciaries will actually abet historic minority rule rather than check majorities in light of this genuine risk of majority tyranny. So, majority tyranny may be something that we have to live with the risk because the alternatives are worse. And it may be something where we can find devices, including like the limitation of judicial power that we create in the name of minorities. But I think we're just at the beginning of a discussion of how to do that. And I just want to reject the naive framing that the tyranny of the majority is the main problem and judges are an ideal solution to solving that problem.
Right, fair point, sir. In your article in Dissent and in one that you wrote for the New Republic about the Supreme Court reform, you seem to suggest that legislatures could be a good way of expanding and protecting individual rights. Would you like to could you elaborate on that? Why legislatures, which are inherently popularly elected, given to the sways of the popular masses?
Of course. So, I think we need to begin with a kind of theoretical perspective and a factual perspective. So in theory, we shouldn't begin by assuming that rights are principally there for the sake of minorities. It's actually the reverse, that historically, given minority rule, it's actually majorities that need rights to protect them from government when it's controlled by the one or the few. And in fact, that's how rights emerged, that when there were kings, rights were claimed as limitations on royal authority, actually by aristocrats. So, the funny thing is that rights protection really emerged not because of the majority tyranny, but because of royal tyranny in the name of the interests of a minority interest, namely aristocratic interests. Now, the truth is that all of the people at that time were oppressed, and the real people who could legitimately claim rights were, of course, the majority that had no political power. Then there were political revolutions. And as part of those political revolutions, their whole purpose was the claim that the people deserved rights. And of course, they claimed those rights sometimes violently. So I guess the real question is, does something change at some point such that the majority gets its rights, and the new problem that arises is the need to guard against, the deprivation of rights by minorities? I'm not sure. So, let's think about the history of my country, and then we can talk about other countries. In my country, most rights have been provided by the legislature. So I don't refer just to the first 10 amendments to our Constitution, the so-called Bill of Rights, which, like all other amendments, were proposed through Congress and ratified by the legislatures of the states. I don't just refer to the amendments after our Civil War, the most important amendments, the so-called Reconstruction Amendments, which were once again congressionally initiated, but to statutory rights. And whether we think of various civil rights acts, voting rights acts, more recently the Americans with Disability Act, which is the rights that the disabled enjoy thanks to Congress, not to any kind of judicial decision. Consider rights for the elderly, like the abolition of mandatory retirement. Again, not a constitutional right, but a statutory right. Consider healthcare, which the Indian judiciary famously reads into the Constitution, since it's a directive principle via the right to life. Ours never does that, even though our country is founded on the right to life, liberty, and the pursuit of happiness. Instead, the modicum of a right to health that we have comes through a statute. Indeed, one that just today barely survived invalidation by our Supreme Court a third time. So from where I'm sitting, it strongly looks like the rights of the citizens are provided to themselves, both for a majority rights and for minority rights. Now, it's true to say that for a brief period, the US Supreme Court attacked Jim Crow. Now, it had actually buttressed Jim Crow in the later 19th century. So in decisions like Brown versus the Board of Education, the Supreme Court was undoing the damage it had wrought in the late 19th century in decisions like Plessy v. Ferguson. More generally, the restoration of or intensification of Black subordination after the Civil War proceeded through judicial invalidation of civil rights acts, most famously in a set of cases called the Civil Rights Cases in 1883. So this is another story where, with respect to racial subordination, you have a Congress passing a rights statute under the color of a rights amendment that it also initiated, and the Supreme Court gutting it. So there's just a lot of evidence that we should rethink and assume that the best source of rights, the rights that are durable and entrenched, is legislation. Now, that's not to say there's never a role for courts, but if it's true that the power to find rights can be used in lots of different directions, not just by legislatures, but by judiciaries, then we have to ask, what do judiciaries actually do? In my country, the evidence seems to support the idea that they protect the rights of the wrong minorities, the powerful and wealthy, and not the downtrodden and the oppressed. Now, I want to acknowledge that that's not the same story as in other countries, but even in other countries, I believe it's fair to say the evidence suggests that the best rights regime are those in which the people have been convinced on a majority basis to provide rights to majorities and minorities. And so political attempts to provide rights are unfailingly superior, and not to mention more durable than other kinds.
Right, and I'll agree with you on that legislatures are much better at entrenching liberal rights than courts. Even in India, our courts are famous for their activism, so-called activism. They read rights into the existing rights, but it's not until the legislature actually gets on that those things concretize from high mighty words on a piece of paper to actual reality on the ground. So I think in the late 90s, we had a really famous case for sexual harassment rights. So should women have the right to sexual harassment, sexual harassment remedy? The court indulged in they wrote a really eloquent judgment. They incorporated some international law principles into our rights jurisprudence. But it wasn't until Parliament passed the Prevention of Sexual Harassment Act that we actually got a concrete system by which to go by. But a counter argument a lot of legal scholars make, that judicial activism, them reading rights into existing provisions, initiates a dialogical process with the legislature, which then intimates the legislature to look into enacting a statute for a particular reason. So then, how do you respond to that argument? Like, should we have judicial activism because it initiates that conversation that we ought to be having in the political branches about enacting new rights or new protections or tackling a specific problem? Or should we depend solely on the legislature to initiate that conversation within itself and then come to a solution?
So it's a wonderful question, and of course you're right. I think I would warn against the assumption that the power to initiate a conversation leads regularly to the conversation happening. It has sometimes happened, and other times not. With respect to the rights that I have liked to study, rights bearing on distribution, you're completely right in your earlier statement that it's really when the legislature, with its budgetary resources, gets behind rights, that the rights become real. But for that and other reasons, I think the South African jurisprudence shows that there can be many conversations initiated where the legislature fails to kind of join in, and the history of its social rights jurisprudence and the legislative response is, I think, really good evidence to that effect. In many comparative constitutional law circles, cases like the Grootboom case on the right to housing have been celebrated without effective study of what the legislature did next. Now, in theory, I see no reason not to imagine forms of advisory jurisdiction, which seems like a credible a theory of institutional design, where it's useful to have outsiders other than just the political constituents of legislators, and with some standing, say that the legislature should consider various constitutional norms and individual rights, and indeed that some laws passed may violate those norms and rights. But then it's up to the legislature. That wouldn't do worse than what we have now, because it still invites a conversation that may or may not happen. My central worry about more empowerment of judiciaries than just this advisory jurisdiction, which seems like a valuable thing to have, some group of judges able to call for a conversation, whether or not it happens, is that the more power we give judges to constrain the legislature or to force a conversation, the more power we have to give them across the board. I mean, it's very hard to give legislatures some kind of power to censor and validate laws, for example, without, witnessing the abuse of that power. And that's even true within the domain of rights protection. So in my country, we think of the right to free speech as very basic, and something that the First Amendment protects. And along the way, we've given our Supreme Court a lot of power to invalidate laws But then it turns out that the right to free speech is interpreted in ways that equates it to the rights of corporations. And so even a kind of seemingly, inarguable amount of power given to judiciaries to defend rights does not save us from their abuse of them. And it's extremely hard then, once that power has been given, to take it away. We're having a whole national conversation in this country about Supreme Court reform, which won't happen because it's just very hard to claw back power given to minorities. And again, that is the central concern. How I think we should center constitutional theory much more on that problem. How do we empower majorities to engage in self-governance, which in most places, almost all places, has never yet happened?
Right. That's again a brilliant point. One thing that I wanted to ask you about the rationale for Supreme Court reform and why we should resist the judicialization of politics. Does this argument, do you think it applies to a relatively young democracy like India, or maybe some democracy in Africa, which does not yet have that concrete political culture within the citizenry, where citizens take rights seriously, with various factional groups existing and there being a sometimes not so admirable contest for power in those countries, even in my country as well. Do you think that in those situations, considering that each country is different, we would want a powerful judiciary to essentially keep the people in check from themselves, protect them from themselves?
No. So, I mean, I begin, with, as a citizen of a country that has a very old constitution, with, the acknowledgement that the Indian one is still pretty old by historical standards. And as my colleague Rohit Day has shown in his recent book, A People's Constitution, ordinary Indians have engaged from the first in struggles over constitutional meaning. And we wouldn't want to accept a kind of, let's call it colonialist imaginary, where certain kinds of people aren't up to the challenge of self-rule, which was always the argument for empire, even amongst progressives like John Stuart Mill and so forth. Conversely, it doesn't seem as if Americans are guaranteed to kind of govern themselves and keep democracy. First of all, they've never had it, given their historic subordination of African Americans and so forth. But second, we've seen in the last few years that they're more likely to throw it away than many other peoples. So I think we should avoid the notion of maturity, not because democracy is easy to keep, but because no one may know how to keep it for forever. And the angling for power you talk about is inevitable in all places at all times. So I think we have to acknowledge that we have that risk of constitutional failure everywhere. Now, is there an argument that citizens have to be acculturated into working within a constitutional regime rather than moving quickly to scuttle it? Again, anywhere in the world? I think so. But I don't believe that judicial empowerment is a credible device of this education. Instead, it's really a kind of it's a matter of political culture. So no, I don't think treating mob rule as something that judges in particular are necessary to counteract is a good way of providing enlightenment to the masses. We just actually have to, engage in cultural and political education to have the kind of politics we want.
That's quite right, Professor Moyn. Even in India, there have been instances where legal, like really respectable legal commentators have indulged in this argument that apparently the people aren't ready for full democracy. So I think you know this. In India, we have something called the unconstitutional constitutional amendment doctrine, where a group of judges can determine whether a constitutional amendment is constitutional or not.
Right.
And it has been used in the past to invalidate constitutional amendments that have been passed unanimously by both houses of parliament and ratified by the states. So it is a very pressing. It's a problem that needs to be addressed sometime later on. As
I agree with you. I just want to say that it's not that I think democracy can't fail, but that our solution to the problem, or our way of counteracting the risk, needs to be assessed for its own defects. And most of these solutions, like judicial empowerment, are really about incurring another risk, which is elite rule. And Plato had an argument for elite rule and the rule of the wise, but we're supposed to be democrats. So I don't think we can revert to that old view which prevailed for so long, that we should just give power to our betters.
Right, sir, absolutely. I came across this post written by the Institute for Justice. It's a libertarian legal advocacy group. It was written in response to your article in Dissent magazine. They made two primary counter arguments. They said that the claims of judicial overreach in the US system is exaggerated by the left and the right, because apparently they did some empirical research and they found that the Supreme Court, in the time since it was set up, has invalidated less than 1% of all legislation enacted by Congress. And they also made the larger argument that if you have a written constitution with separation of powers, you are going to end up with one branch which has to determine what that constitution means and hold the other two branches to it. So what I want to ask you here is judicial review inevitable in a written constitutional system? Do we always, like, if we have a written constitution and we entrust the power to interpret it to one branch, are we going to end up with some form of judicial review which checks the other branches?
Okay, so there's an empirical point and there's a kind of philosophical point. So on the empirical point, I would never deny that the invalidation of legislation has been routine. It's been very rare in the scheme of things, but when it happens, it's grievous, and it's happened frequently, and enough to be of great concern. I mean, that happened in the 19th century, in ways that supported, the slave order. After the Civil War, as I mentioned, it gutted Reconstruction and the attempt to provide equality to Blacks. It supported the interests of the wealthy and powerful in the so-called Lochner era, and in some of the most offensive decisions, overturned Franklin Roosevelt's early attempts to face the Great Depression and enact a New Deal alternative. In our time, it's been on the rise, and it's been, I think, very, very damaging. So what we're talking about are the big laws that are supposed to make major changes and that the court censors or invalidates, and that happens often enough to be a cause for concern. And I'm not arguing for eliminating the Supreme Court, since we need statutory interpretation and we need cases and controversies resolved. The question is, your second one, as a philosophical matter, who should have the last word on the meaning of the Constitution? And should judges in being assigned that last word, or just taking it, as in the case of my country, be empowered to be so aggressive in the cases I mentioned? I don't see why. I mean, I understand that in a system with an unwritten or written constitution, there's the need to have a discourse about whether we are being true to it, how we are transforming it, and so forth. It doesn't at all follow that the judiciary gets the final or ultimate word. We've discussed the possibility of an advisory form of jurisdiction where judiciaries can be invited by litigants to note that there may be tensions between laws and constitutional values, but the ultimate decision about what the Constitution means should devolve on the people as a whole and their legislative representatives. So, we could imagine some other system where no single actor has the last word. It's very hard to figure out the design principles for such a system. It's sort of why I favor, at least in the American situation, all I've argued is for transferring some power to the legislature while leaving the Supreme Court the last word in some instances. For example, when all the justices are unanimous. But one could imagine the position that the Supreme Court should have no power and just advisory jurisdiction. And that wouldn't mean that we're not living under a constitution, but that the legislature and the people electing them are ultimately responsible for its enforcement and its very meaning. I'll just say in conclusion to this answer, for most of modern history, progressives, broadly defined, look to the British model, not because they favored an unwritten as opposed to a written constitution, but because they believed that the parliament, especially once democratized, should have the authority through statute to determine the evolving meaning of the Constitution. The American situation with judicial empowerment was regarded as an anomaly and indeed reactionary, for good by reactionaries, but for ill by progressives. And if you take the founders of India, these are people who look to a parliamentary model, even when they decided to write down a very long constitution. And the judicialization of Indian constitutional politics is much later. So my basic view is that the default used to be that the legislature was the really exclusive constitutional actor, until we decided to Americanize and believe that we should give more power to jurists in general and justices in particular to have the last word. And I think we've paid a price.
Right, Professor Moyn, that's a really great point. I wholeheartedly agree. Even in India, we've had some sorts of a judicial power grab over the years since the 1980s with judges including various facets of the Constitution or various laws into the basic structure doctrine and holding themselves the power to define what that basic structure means. It's a really unfortunate situation, but nevertheless, it's a conversation that we are trying to initiate here today. Picking on your point about the legislature and giving power of interpreting the Constitution to the people themselves, most legislatures in the Anglosphere and countries which follow the British parliamentary system are elected on first past the post voting system. So in effect, we more often than not end up in a situation where 40% of the country votes for a particular party, and that party forms a really powerful government with a healthy majority. So then we're still faced with the same problem where it's not actually the true democratic majority making decisions. It's a large minority of them that have gotten together and that have voted for a party. So how do you resolve that difficulty vis-a-vis judicial review?
I think it's a fair question, and I'm not, I wish I had a better answer. It seems to me that there's no correct answer beyond controversy about how to organize democratic representation. So we can always claim both that we need to experiment more and that the way we've done so is not adequately representing the people or a majority of them. I think that the model you've cited is minoritarian, not majoritarian, unless there's a requirement of a coalition that provides a majority of the seats in parliament, which is a requirement in at least many parliamentary regimes. Even if even in the situation you describe, it requires a new and separate argument that an empowerment of the judiciaries is the way to counteract the power of the ruling minority, and that doesn't follow automatically. It has to be argued, and I think that the track record is not encouraging. So I think we should focus on the debate on what in experiments in representation we would like to attempt and demand, rather than accepting minority rule even when it's a plurality and then counteracting its defects through empowering some other actors who are inevitably come with their own class and other privilege and perspective, which is particular and can't be assumed to be reflective of universal norms or the popular will.
Right, sir. Coming back to the specific American context now, as you know, President Biden has set up a Blue Ribbon Commission to report on Supreme Court reforms.
I'm not sure about that.
Just a second, sir.
Sure.
President Biden came up with the Supreme Court Commission to report on Supreme Court reforms, and a lot of suggestions are floating around in the political sphere. Some argue for expanding the number of judges, but you have taken on a very interesting argument. You have argued for disempowering the Supreme Court, arguing that expanding the number of judges, or court packing as it's called, will not cut it. What's your perspective behind that? Why disempower when you can get what you want more easily by adding, say, 3 or 4 justices?
Well, first of all, you can't get what you want because there's not enough support for expanding the court, even among Democrats. But even if there were, it seems like a short-term solution for 2 reasons. One is that it makes for more friendly judges in the short term, but doesn't have any ramifications for what they do in the long term. And I think we should learn from the conservatives who had a syndrome of their hand-picked judges becoming progressives during their time on the bench. And then there's the second reason, that one expansion of the court will invite another. And regardless, none of these expansions, aside from consuming national debate, just as our current appointments process does, would change how much power the Supreme Court can wield in the censorship or invalidation of laws. So if we decide that that's the problem, not the identity or number of judges on the bench, then we have to adopt a set of reforms that actually attacks that problem. And it's not that adding a few justices now wouldn't lead to different outcomes. It would, but it would lead to different outcomes because the judges decide to represent the ideologies of those who appointed them in the first place. And that is not something we should guarantee, that we can guarantee. More than that, we shouldn't want it to need to guarantee it, as if we have a certain majority, and instead of enacting our will through statutes, we use our majority power, which is, brief and evanescent, to put our representatives on the bench instead, to rule like by proxy. But that's what democracy is for, is to have representatives in the legislature rule by proxy. So why not just do that?
Right, Professor. One of the counter arguments that people who are opposed to disempowering the Supreme Court make is that one of the primary jobs of an independent judicial branch is to check the executive branch, to check the president, make sure that that the president is exercising his or her authority within the ambit of the Constitution. Given
Yes.
how gridlocked Congress can be at times, wouldn't it be unwise to disempower the Supreme Court when it comes to that specific point of keeping a check on executive excesses?
I don't believe so. I strongly think that we should have a way of condemning executives who are operating ultra vires and exceeding the law, not just the Constitution. But Supreme Courts can also be very friendly towards executives. In my country, essentially the executive has been given the power by courts to violate a whole series of laws, notably with respect to initiating war. And we've seen other kinds of controls on things like surveillance of domestic and even worse foreign populations, essentially approved by judiciaries. So the idea that judiciaries provide a check on executives that is a serious check is already open to question. And then we get your comparative point that a gridlocked Congress is unlikely to do better. Well, I don't know. Under Donald Trump, and finally, some people woke up to where they had been, to the way that they'd been empowering the executive in recent history, and Congress seemed to get very aggressive. And indeed, the Supreme Court place limits on Congress in checking the president as much as it did on the president himself. So finally, let me make a point that is very important, that comes from my main inspiration as a theorist in these matters, who wrote a century ago, named James Bradley Thayer, who argued that empowering one agent has the potential to stunt the power of another agent. So he claimed that making the judiciary powerful would lead the legislature to abstain from its responsibilities. And so, it can also be argued that, I've mainly argued that the judiciary just isn't very good at checking the legislature. The racist travel ban is another example in our country. But to the extent that it is, the comparative question really depends on what the world would be like if the judiciary weren't empowered in that way. And we can hypothesize, or at least hope, that Congress would have different incentives. Now they can, let's say, rely on the judiciary to do their job. But if the judiciary weren't empowered in the way it is, it would be the legislature or nothing.
Right, Professor. Speaking from a comparative constitutional law point of view now, do you
Yes.
see merit in reforming the American constitutional system to reflect somewhat of the Canadian system, where the Supreme Court does have the power to invalidate a legislation, but if Parliament passes it again, it has to go ahead anyway?
Right. Yeah, I do favor a legislative override and other techniques of that kind. I mean, I haven't committed to any particular disempowering technique of in the American system, we've had other debates about jurisdiction stripping and supermajority rules, but a legislative override, which is really a kind of jurisdictional tactic to make the Supreme Court kind of an advisory body, since the power of the last word would be on Congress to accept or overturn the judiciary's findings. And I definitely support that. I think we have evidence in Canada and Israel that this power of legislative override is rarely used. And so it suggests that that the power to override actually changes the behavior of the judiciary in the same way that depriving anyone of the last word means that they speak differently.
Right, Professor Moyn. We are nearing the end of our 1 hour, so I guess we'll come to the final point of discussion. In his really admirable book, The Dignity of Legislation, Jeremy Waldron took legal academics in particular to task for indulging in this judiciary-centric dialogue and leaving out the legislature as a respectable source of law and as a respectable protector of rights. So I guess my last question to you, like a series of last questions to you, will be: do you agree with that viewpoint? Do you think it's time for people in citizens of constitutional democracies like the US, South Africa, India, to rethink how we imagine constitutional courts in our system? Like, are we as citizens of constitutional democracies ready for that change? What are your thoughts on that?
I think citizens are. I think the question is whether jurists are. Jeremy, who's one of our greatest scholars, wrote an interesting book review of my own mentor and teachers, Roberto Unger's book, which is it acknowledges that it's really a defect amongst jurists who, in a sense, don't like democracy as much as juristocracy, because the latter gives them a more important role, either as jurists or advisors to jurists. And so, maybe the trouble is with the legal culture, especially in elite circles, which is not very interested in democracy, doesn't want the legal advisor to be primarily a helper to the citizenry, and rather than the higher judiciary. And so my sense is that there's a latent interest in democratic self-rule, and the trouble is as much more with our legal culture and the elitism and elite rule with which our legal culture globally has often been bound up.
Right, Professor Moyn. There's still some time remaining. I'll sneak in one last question. Judicial reforms, going back to the American context, there are those on the right who have ostensibly claimed to be supporters of democracy, who don't like judicial overreach, judicial activism, etc., etc., etc. Do you think that Supreme Court reform can be one of those really few things the left and the right could work together on to achieve a more meaningful solution to this judistocracy problem that's plaguing American democracy and in some ways plaguing my own constitutional democracy here in India?
I hope so, because I think, to be very frank, that the conservatives have had the better of the argument when in certain cases liberals won and conservatives complained that not the outcome, but the process by which it was reached was not democratic. And they may have made that argument on principled grounds or unprincipled ones, because of course our conservative jurists and judges have never been above undemocratic rule themselves, even more so. But I think we can attempt to hold conservatives to their historic rhetoric as friends of democracy and a judiciary with limited powers. And so one reason I favor some of the reforms I do is because where court packing appears to conservatives rightly to be a naked power grab, in the same way that what Mitch McConnell did in our country, was a naked power grab for conservatives. Some of these other reforms are neutral in means. I mean, they would favor progressives, I believe, but there's no guarantee, because ultimately they favored the democratic process. And so I hope it's possible to build a coalition across partisan lines for some of these reforms. But the truth is, now conservatives have such power in the federal judiciary that they're very unlikely to give it up, even when they've, given many principled reasons why they should do so.
Right, Professor Moyn. That'll be all. Thank you so much for sitting down with me. It's been a really fascinating talk. To the people who will be watching this video later on, there's a really, really interesting website called Supreme Court Reforms that Professor Moyn has set up with students at Yale Law School. You should go check it out. It's like some of the arguments there, some of the reforms proposed there are really ingenuous. Professor Moyn, thank you so much for sitting down with me, for giving us time today.
Thank you for having me.
And on that note, that we wish you the very best in all the things that you go on to do ahead.